counterparts, and good afternoon here in eastern South Dakota. My name is Gary Timpson, and together with Sarah Theophilus, we are chairs of the South Dakota State Bar Veterans Committee and sponsoring this webinar on the Servicemember Civil Relief Act. We are very privileged to have two very eminent speakers, Professor Emeritus Greg Huckabee, who, when serving in the United States Army Judge Advocate General Corps, authored this piece of legislation that you have and has done an excellent summary of it. And there is retired Air Force Colonel John Odom, who is a litigator, former Air Force JAG officer, and has litigated prolifically the Servicemember Civil Relief Act. And I think between the two of them, they can give you a lot of information that will be of benefit to practitioners, both on the plaintiff and the defense side of civil litigation. What this course is not about, or this seminar is not about anything to do with criminal law, and it's not about how to get your VA disability rating increased or whatever. This is about how the Servicemember Civil Relief Act applies in civil litigation involving current and former military members and their dependents. Anything that I should add to that, either Professor Huckabee or Colonel Odom?
Sounds great.
If you'd like to add anything, otherwise, I will turn it over to you, gentlemen, to begin the presentation. And thank you on behalf of the South Dakota Bar Veterans Committee, and in fact, the entire South Dakota Bar Association, for your effort and time contributing to this program. Thank you. Let's go.
Thank you, Gary. It's a privilege to be able to discuss something that Colonel John Odom and I have spent a significant portion of our professional lives working with, the Servicemember Civil Relief Act. Colonel Odom is a retired Air Force Reserve Judge Advocate, who, in my very humble opinion, is the premier civil litigator in the country involving the Servicemember Civil Relief Act that you will hear and learn about in just a few moments. Before jumping into the statute itself, I thought you might enjoy learning a little bit about its history. All of us are familiar with a fellow by the name of John Wigmore, as in Wigmore on evidence. Well, Major John Wigmore was a judge advocate in World War I, and he chaired a committee that drafted the first Soldiers and Sailors Civil Relief Act that was enacted by Congress in 1918. And it was great to read his testimony before the House and Senate Military Affairs Committee, because he was really treating them like students in a law class. It was really interesting to hear him chastise congressmen and senators when they were asking silly questions. Well, we're hopefully going to invite you at the end of our presentation to provide us any questions that may surface. So, as I mentioned, Major Wigmore was critical in getting the first Soldiers and Sailors Civil Relief Act passed in 1918. But guess what happened? At the end of World War I, the act expired by its own provision, that when an armistice was signed, it would expire. Well, fast forward to 1940, obviously on the eve of World War II, Congress reenacted verbatim the Soldiers and Sailors Civil Relief Act. Great. Well, fast forward now to Operation Desert Shield and Operation Desert Storm in 1990, 1991. On August 2nd, 1990, when Mr. Saddam Hussein invaded Kuwait, obviously we went to a war footing. Our Judge Advocate General at the time, Bill Suter, called everybody in. I was stationed in the Pentagon at the time, the Deputy Chief of Legal Assistance, and he called everybody in and said, look, we are going to mobilize reservists and guardsmen for the first time since World War II. So I need to have all of you look in your respective areas to see, is there anything we need to do to help mobilize and deploy soldiers, sailors, airmen, and Marines? Great. Okay. So I spent a night going over the 110-page statute, Soldiers and Sailors Civil Relief Act, only to discover, to my complete horror, that it was outdated. For example, there is a provision that prohibited a service member from being evicted from their home without a court order, provided the rent did not exceed $150. Oh, yeah. Well, the whole statute read like that. It just hadn't been updated since World War II. So when I dashed down the hallway of the Pentagon to my general's office and explained to him the SSCRA is out of date, it's, essentially expired for all intents and purposes, it needs fixing. So he said, all right, let's go see the DOD General Counsel. So we marched up to his office and explained our little crisis, that we needed to have revisions made to the statute in an expeditious manner, because we were going to be mobilizing all these guardsmen and reservists. The DOD General Counsel said, fine, we're going to put together a task force then. Each service will provide one judge advocate. So there'll be four services, four of us, and you will draft whatever the revisions are, the updates that need to be made. But you cannot include anything new in terms of protections. We have to go with the current protections that are there that just need updating due to passage of time. Well, okay. Well, so we had 4 judge advocates. I represented the Army, and we would meet. We divided up the statute by 4, and we would meet on Fridays to go over the homework that we had done, trying to update the specific sections we had. I learned very quickly the importance of the C word when you do legislative drafting. The C word being, of course, compromise. One of the things that the DOD General Counsel made very clear to us is that we needed to have unanimous agreement among all 4 services on any provision to change or amend the SSCRA. I can tell you from having spent 5 years in the Pentagon, the hallways are littered with the bodies of service members who have engaged in internecine warfare among the services. So trying to get all of the 4 services to agree on anything is a significant emotional event. Yet we learn from experience, look, the only way we're going to get these revisions done is we have to agree to disagree, but we have to compromise. So we move right along, and cooperation, the C word, came into vogue, and we managed to get our draft done until a bright Air Force captain, Amy McDonough, I have to give her credit for this, said, well, look, we need to change the name of the statute because the Soldiers and Sailors Civil Relief Act, when that was created in 1918, we didn't have an Air Force. And then our Marine representative said, well, we need our name in there too. So I'm sitting back in my chair, looking at them going, wait a minute, Soldiers, Sailors, Marines, and Air Force Civil Relief Act? No. Too long a title. This is going to get hung up. We won't get this through Congress as is. We have to come up with something else, but what's wrong with Soldiers and Sailors Civil Relief Act? Well, we sort of log jammed on that, but decided to set it aside for a week, and we come back and rediscuss it, which we did. And Captain McDonough was adamant again that they wanted to have the Air Force name in there. So we sat back and says, all right, can we come up maybe with a new name? And Lieutenant Chris Gentili from the Navy said, why don't we just call it the Servicemember Civil Relief Act? We all agreed on that. We did. However, I still have the teeth marks on my gluteus maximus from my Judge Advocate General for having traded away the statutory title of the Soldiers and Sailors Civil Relief Act. Oh, well. Well, that brings us to, of course, finishing our work in 1990. Actually, it was November 1990. We finished our drafting and went across over to Capitol Hill to Congressman Sonny Montgomery's Veterans Affairs Committee. He said he would get it through Congress, all of our updates and revisions. He was good as his word, and President Bush signed it in early February 1991. Well, we no sooner had the end of Operation Desert Storm in early March of 1991, and Congressman Montgomery decided he wanted a complete update of the entire statute, putting in new protections that didn't exist before. So he asked the DOD General Counsel to round up the Gang of Four and get a complete overhaul done, but also include whatever new protections we believe were needed for reservists and National Guardsmen. So we finished that work in June of 1991, only to be confronted with Agent Orange, which took up every moment of legislative time. So it didn't get enacted by Congress. And so we fast forward to 2003. I was now the deputy chief of the deputy staff judge advocate at First Army in Atlanta. And our legislative liaison at DOD, Colonel Don DeLine, called me and asked me, "Did you hear it?" And I sat back and asked him, "Colonel, hear what?" He said, "The window of opportunity just opened. So get your Gang of Four together and let's get this thing through the Veterans Affairs Committee and enact it." And it did. I mean, it blazed right through Congress and became law. So we're going to walk you through the provisions that we believe are certainly needed today by our reservists and National Guardsmen, and note any questions you may have, and we'll try and address those at the end. With that, I want to call on Colonel John Odom. You're going to hear some incredible stories as the premier civil litigator for SCRA cases. Now, John is, he got mobilized, as he mentioned earlier, as part of what was going on. And to his credit, he mobilized the standing committee of the ABA for Military Affairs, the LAMP committee, and got the ABA behind the SCRA. And when we were taking our own sweet time to make changes, he mobilized us to get moving and got the ABA behind the SCRA. And I can't think of another person to address the litigation involving the SCRA than Colonel Odom. So with that, Colonel Odom, the floor is yours.
Thanks, Huck. Let me just piggyback, and I won't do this, but this one time, let me piggyback on what Huckabee just gave you as the introduction. He can go on and on about how it came about, and it's a fascinating story. But one anecdote that came from the congressional record that he referred me to about the hearings with Major John Wigmore, late of the Northwestern School of Law in Evanston, Illinois. One of the senators said, "Major Wigmore, there's a famous legal scholar by the same name of Wigmore. Do you know him?" And the reply of Major Wigmore was, "Yes, Senator, I am he." And that was the last question that senator had. They understood that they really had a foremost military or legal expert who was the principal drafter of the legislation. And let me just say that when I get to team teach with Huck, and we've done this dog and pony show before, I feel like I'm asking Moses as he comes down off of the mount with the 10 commandments, like, what did you really mean by number 7? Or what was your intent in number 8? He is the daddy rabbit of all of this. What I have been able to do is make the last half of my legal career, which now spans 53 years, I've managed to make the last half of my legal career an implementation of much of the legislation that Huckabee is responsible for. Now, you'll see on the slide, we're going to teach 2 things in this course today. We're going to teach theory, that's Huck. Practice, that's me, because I'm the one out there filing the lawsuits and fending off the motions that the defense counsel can come up with. So let me explain to you that SCRA practice is primarily one of education, just what we're doing today. Now, the Air Force calls this trying to take a teacup sip off of a full pressure fire hose. We're going to give you much more today than you can possibly absorb in an hour and a half. But the Bar Association and Tracy Bradford are going to put all of the slides up on the website of the South Dakota Bar Association. And you're going to have 2 slides at the end that give Huckabee's contact numbers and my contact numbers and emails. And if you have questions, we're happy to help. If you have specific fact patterns, the only thing we ask is that rather than do that over a long phone call, put that in an email to us and we'll get back with you. But okay, so what I have to do when I file a lawsuit, because most of the defense counsel have never heard of the Servicemember Civil Relief Act unless they represent banks or mortgage companies or car financing companies. They're just not familiar with it. So I have to educate them first. And I am so tired of hearing one of them say, you can't be serious. The law can't do that. Well, yes, the law can do that, and it has done that. And when I get through educating the opposing counsel, I frequently have to educate judges, but more importantly, their law clerks on what this law does. But I have learned in my litigation practice that rule number 1 is the SCRA means only what the judge that you're in front of at that very moment thinks it means. And so it's a matter of education and persuasion, quite frankly, to make sure that they understand that the judges have certain rights, that they can do things with the contracts that are hard to understand because the act alters the terms of those contracts when the contract becomes subject to the protections, rights, and benefits of the statute. Now, here's some trends that I'm seeing. The creditors are getting much more savvy about this. When we first started doing a lot of SCRA litigation back in 2001, when the planes hit the towers, nobody understood litigation under the SCRA. It was really a new deal. And everybody, if you'll recall, back in those days was flying flags from their cars, and nobody could do anything but thank the soldiers for what they were doing and so forth. It's not like that now. The war went on a long, long time. And so we have creditors who are getting a little bit more aggressive. Back when I first started this, banks would do anything to keep publicity out of the newspapers and off the television that they were foreclosing on the home of a service member who was deployed to XYZ country. Now, I don't think a lot of them don't care now. Second point, that the new SCRA that was adopted and became effective in December of 2003, it isn't so new anymore. We've had 20 years to work on it, and it needs some updating now. And we find that courts are issuing opinions that are much more narrow in scope than it was the case in 2002, 2003. Appeals are expensive and very rare, and so you don't see very many reported cases about the SCRA. They just don't exist because either people get tired and run out of airspeed and altitude, or they just get frustrated and quit. And that last bullet, for those of you who do a lot of federal court litigation, and I prefer federal court, we still use legal length paper in state court in Louisiana. And I like to say that federal court is short paper court. They have cleaner bathrooms, better security, and you can use short paper in your printer. Most of my litigation is in federal court. I'm going to tell you right now, the next multi-billionaire in this country is not going to be another Elon Musk or another Bill Gates. It's going to be whoever can figure out a search engine that works in PACER. That's the Public Access to Court Electronic Records. Because what we see now is even opinions on 12B6 motions that are posted on PACER are now being cited as authority. And that's sometimes the only place you ever find what a federal judge somewhere has said about a particular provision of the Servicemember Civil Relief Act. So that's the trends that I'm seeing. Here's what you have to be able to understand yourselves and be able to convince opposing counsel and the judges. This is an incredible consumer law. It alters the terms of conventional contracts when those contracts become protected by the SCRA. If you have a mortgage, for example, that allows for non-judicial foreclosure, take a red pen when that mortgage becomes protected by the SCRA and strike that language because it is no longer effective. And you try explaining that for the first time to a mortgage company's counsel, and it's going to take you a long time. The Act prevents default judgments except when they're done in accordance with its provisions. The law doesn't say a mortgage holder can't foreclose. The law doesn't say a creditor can't take the default judgment. It simply says, here's the process by which you must go through to take that default judgment validly, or here's the process you must go through to foreclose or seize that mortgaged property. You can do it, Mr. Creditor, but you must do it in accordance with the terms of the statute, and very few of them do that. Let's see here. It allows for the cancellation under certain circumstances and with compliance with the statute of leases on premises and also on truck and automobile leases. This did not exist in 2001 when the war started. And I went to help mobilize a Marine Corps Reserve unit here in town that was getting mobilized, man and boy, 135, all called to active duty immediately. And what I found was when I went over to their headquarters one Saturday morning to give them this briefing, I discovered that apparently the Marine Corps issues brand new Ford F-150 pickups to all of its enlisted people because everybody on that parking lot had a newer truck than I did. And I was upset about it. And then I found that almost every one of those trucks was leased. And guess who the co-signer of their leases were? That would be their father. And they were paying much more attention to how I was telling them there are ways to get out of that lease. But the new act, the 2003 Act, has specific provisions about how to cancel auto and premises leases. It reduces, this is the one that everybody remembers, it reduces the interest rate on pre-service obligations to no more than 6% if the soldier, sailor, airman, Marine, Coast Guardsman can show that they're materially affected by virtue of the call to service. Now, that material effect is generally meaning you make less on active duty than you did in the real world. But I have to tell you, very, very few creditors, in my experience, ever take the time to challenge material effect until they get sued. And then they try to challenge material effect. And at that point, I say they've waived the challenge. But pre-service obligations are the ones that are subject to the interest rate reduction. One of the latter provisions in the Act gives the consumers in what we call the anticipatory relief provision. It gives consumers the opportunity to essentially restructure all of their debt with court approval, and it's not a bankruptcy. It doesn't count on your credit score as a bankruptcy in any way. So they're just it's an amazing statute in its breadth and what all it can do. Huck's going to tell you who is protected under the statute.
Absolutely. Well, certainly all active duty military members called to active duty under federal authority, but also reservists and National Guard members. So it has particular importance for South Dakota because we have Guard units that are going down to work on the border. Yes, they are covered by the SCRA. So virtually, you know, whether it's, and this is the purpose. Both of these paragraphs come from the original 1918 SSCRA. They really captured what the point of the statute was way back then, and so we decided to keep it verbatim in all of our succeeding definitions and statute writing. I love this one. This is one of my favorite Supreme Court cases that look, the SCRA was created to protect those who have been obliged to drop their own affairs to take up the burdens of the nation. Next. Here's my second favorite one. The act should be read with an eye friendly to those who drop their affairs to answer their country's call. Another Supreme Court case 5 years later. When you read both of these together, you can see that the tie ought to go to the runner. And so if there's any argument over ambiguity of statutory interpretation, which happens, the service member should be given preference, and as the Supreme Court has said in both these cases. So the SCRA used to be found in the appendix to the federal statute, but it's been moved up now to the varsity line and is now codified, as you see there, under 50 U.S. Code.
Huckabee is so much smoother than I am. Huckabee would get a creditor on the telephone and say, now, I understand that you read the statute and the protections as A, B, and C, but we read the protections as X, Y, and Z, and I can understand your position, but you need to hearken to my position because we have these two Supreme Court cases from 1943 and 1948 that say basically ties go to the runner. My approach was somewhat different. I was back on active duty for a couple of years prosecuting a court martial, and I got a lot of inquiries about SCRA stuff during that period of time. And I would call the creditors counsel, and he would say, no, that can't be what the law says. And I said, yes, that's what the law says. And I would get frustrated. And unlike Professor Huckabee, my negotiating skills are different from his. I would say, can you look out the window of your office and tell me exactly what you see? And I'd say, what? I said, well, I mean, do you happen to know the exact precise geographical latitude and longitude of the building that you're sitting in? And can you tell me which window you are on the whatever floor you are? And why do you want to know that? Because I have some friends upstairs at 38,000 feet that are going to send a small diameter weapon through your window if you don't hurry up and give this poor soldier or sailor the protection that they deserve under the law. Huckabee found that type of negotiating style to be offensive to him. So I don't do that anymore. So anyhow, in 2010, we finally got some amendments that had been long needed because litigation under the statute had been met prior to that time by a 12B6 motion to dismiss. The basis of that motion would be that the statute did not have specific provisions in it allowing for a private cause of action to enforce the statute. Now, I had defeated those motions every time, but I really got tired of having to write the same briefs over and over, and we started lobbying Congress. And finally, in 2010, we got two new amendments. We got a complete new Title 8 to the SCRA, but we got some amendments. The Attorney General wanted the same type of official authorization to go after bad actors. And believe you me, when a bank or a credit company or a auto finance company gets a letter from the U.S. Department of Justice saying, we'd like to review all your files, it gets everybody's complete and undivided attention very quickly. The statute also now gives them the specific authority to issue administrative subpoenas to get those records. But most importantly, the private cause of action was now recognized in the statute in Section 4042, and it includes a provision for reasonable attorney's fees and exemplary damages where appropriate.
This is, if I may interrupt, this is referred to in the Pentagon as the Odom provision, because we didn't have this, as he mentioned earlier, in previous editions of the SCRA. And he said, no, I think we need to specifically state in the statute that private cause of action to recover damages is authorized, and so are attorney's fees. If we have this in the statute, we will mobilize the entire American Bar Association to support service members vindicating their SCRA rights. So the Odom provision is alive and well and crystal clear.
Thanks, Huck. We refer to the Odom provision in my household as the Odom retirement provision. But anyhow, all right, proceeding on. The act is organized into, I'm sorry, and also the 2010 amendments also have a specific section in there that said the act does not overrule state causes of action that might provide greater protections. So the preservation of other remedies is also enacted in all of the SCRA now. I'm going to run through these pretty quickly because we want to get to some of the specific provisions. Title I are the general provisions about who's protected. Title II is where you find the general relief provisions about how to take a proper default judgment, the statutes of limitation. Wait till we get to that slide. That's going to blow some minds this morning. The maximum rate of interest is lowered to 6% with the appropriate notice and so forth. Title III is where the major substantive protections are. That's the protection against evictions, except in compliance with the statute. Foreclosure and repossession of contract goods, again, except in compliance with the statute. Evictions, seizures, mortgage foreclosures, and repossessions of immovable property called real property in every world except Louisiana, where we have the French Civil Code, but without a prior court order issued after a hearing that has service on the service member and an opportunity for him or her to be heard by a neutral and detached magistrate as a third-party intermediary inserted by the statute between the service member and the creditor. That's what Title III does. Those are where the big provisions are. They also have a provision in there about storage. I started to say Storage Wars. That's a show on A&E Network that I watch for CLE credit. You can't cut the lock off a storage locker and sell the goods, even though the rent had been paid, if those goods are owned by a service member. You have to go get a court order to do that. I made a lot of money off of people that didn't understand that. There's some stuff in Title IV about life insurance that we're not going to touch on. Title V has to do with residence for taxation purposes. That is an important point. If your state does try to tax the either the real or personal property of service members. Title VII goes into that anticipatory relief that I talked about. Some of these provisions in Title VII are going to be very, very important. If you have clients, for those of you who are in private practice, if you have clients who are partners in law firms, for example, or who are members of businesses and they have business associations and they have to leave because they've received orders either from the Guard or the Reserve or the active duty force to go on active duty, they have rights that are welded into this statute that upon their release, they can come back and resume their lives. So if you have clients that are in that situation, I urge you to be very mindful of the protections. For example, lawyers who get called to active duty can notify their malpractice carrier and suspend their coverage for the duration of their service. Then when they are released from active duty, they notify the malpractice carrier and they resume their coverage without any further investigation. So these types of, same thing with self-funded health insurance. You get on active duty, you're covered by the healthcare system of the government, and you don't want to pay those horrible medical insurance premiums while you're on active duty for you and your family. Well, you can give your insurer notice in accordance with the statute, and they have to suspend the coverage until you tell them you're off active duty and you want to resume the coverage. It's a phenomenal benefit that a lot of people don't know about. So it's very important that those of you who have individual clients who might be Guard or Reserve or just going on active duty, they know about these benefits. Title VIII, we've already touched on the Odom provision, the preservation of other remedies, and the enforcement by the Attorney General. Okay, Huck, I think, let's see. I think we're up to you, aren't we? Definitions. I'm sorry. I'm going to do the next one as well. Service member would seem to be a self-defining term. You cannot imagine how complicated it actually is. especially for members of the Air National Guard and the National Guard. The Guard is simply different, and they become service members. It's very clear. If you're on Title 10 orders, if you're on active duty in one of the active components, or if you're on active duty in one of the reserve components of the Army, the Air Force, the Navy, or the Marine Corps, or the Coast Guard, you're on active duty. You're on Title 10 orders, federal active duty. But if you're in the Guard, your orders determine whether you're on state active duty or federal active duty. And you're only on federal active duty if you're called up for a period of 30 days or more, and your orders say that the call up is specifically under 32 USC 502F. It has to be in those orders, or you may not be covered by the federal SCRA. Interesting tidbit, officers in the National Oceanic and Atmospheric Administration, NOAA, are also protected by the SCRA, as are public health service officers. And public health service has a reserve corps, and I have assisted physicians in the public health service reserve corps who left their practice, got released from public health service orders, and wanted to resume their practice, and their partner said, no, you resigned. No, he didn't resign, and he can come back to his practice. So there are certain circumstances, as the bottom bullet there shows, that the dependents, the service member's spouse or child, will have the same rights upon approval by a court that the service member does. And then any person that has for whom the service member has provided more than 1/2 of their support for the 180 days prior to the relief under the Act, that's a holdover from the Wigmore deal, when most of the men that were going to be drafted for World War I, most of them lived on farms, and their industry, their labor, their money helped to pay the family mortgage. And when they got called to service, that $12.50 a month that the private was getting in World War I wasn't enough to help save the family farm. So that's what that provision was originally designed to protect. It's still in the law, and it still makes sense. Okay, now then, here is a definition. Section 3911 includes the definitions, and the 2003 Act made a huge change in the definitions of what courts are included. As Gary said in the introduction, no criminal courts are included. This is strictly a civil matter, but courts are now defined, and they include all courts, whether it's bankruptcy, or whether it's family court, or whether it's an administrative agency. So if the town council of Chamberlain, South Dakota wants to fine me for my dog misbehaving in the pheasant field, and I'm called to active duty, I can apply for a stay in those proceedings of the town council, because it is a state, federal, or local body of elected officials. I can apply to that for a stay under the SCRA. Adding those administrative agencies is a huge expansion of coverage under the SCRA. And for those of you who practice family law, it's a tremendously big advantage to know this, because those administrative law judges, or those hearing officers that we run into all the time, who set the initial child support and custody arrangements, they are subject to the SCRA as well, as far as stays of proceedings and as far as default judgments are concerned. Here's the last bullet down there. Mandatory arbitrations are not covered by the SCRA if the service member has voluntarily entered one of those mandatory arbitration clauses. So that's a bit of a different deal. And then finally, we got the word judgment added in the definitions paragraph in section 3911, and it's a very broad definition in the new Act. Any judgment, decree, order, or ruling, final or temporary. This is especially important in family law practice, because there are a lot of temporary orders that are issued immediately, including custody orders, and those are considered judgments under the SCRA. So this is a potential pitfall for the domestic relations practitioners, and I want you to be very, very conscious of the rights that you and your clients would have under that. there is a provision about personnel who are secondarily liable. This is co-makers, co-signers, and so forth. You're going to find that the parents of a lot of our enlisted troops are extremely interested in this particular provision. So you need to know about that if they have co-signed a note for someone who becomes protected by the act. Okay, Huck?
Well, there's always the question of, when does the act apply? It's not unusual for reservists and guardsmen to receive a telephone call saying, okay, Sergeant Schmudlap, we need you to report to our mobilization station day after tomorrow. So you've got oral notification. But what about written orders? It is not unusual for those to take some weeks and sometimes even months before they will catch up with the service member. Well, what triggers the SCRA? Notification, that telephone call, that triggers the SCRA. Any form of notification will trigger the application of the SCRA protections. So the whole point of the exercise is to provide time for a service member to try and get their affairs in order, and you may have, as Colonel Odom has already mentioned, multiple people who are signed on to different lending documents and all. And it's supposed to be in mobilization stations, you're supposed to have a judge advocate there who tries to help service members figure out what their obligations are and how the SCRA can apply to them. And actually, the judge advocate actually prepares the letters that the service member can use to request SCRA protections from creditors and other parties.
The spin-up period that Huckabee talked about is incredibly important. And for most of the guard personnel, they will be at a weekend drill when their commander comes in and says, we are being mobilized, orders to follow. That's called a VOC, a verbal orders of the commanding officer. But that verbal notification to them triggers the coverage of many of the sections of the SCRA. For those of you who may be guard or reserve, know that it's very important that the commander give those troops a letter that says, this unit is being mobilized. We anticipate going on full-time active duty on such and such a date, but they have been notified that they will be mobilized for a period in excess of 30 days for guard personnel. That's really important to help them get their employers or their creditors to understand that they're now protected by the act. Under Section 3918, it is possible to waive your rights under the act, but the waiver must be in writing, and it must be in an instrument separate from the written instrument that created the obligation. So what we see is creditors trying to be sneaky, embedding into the promissory note or into the original mortgage a waiver provision. I take the position that that is not a separate instrument, obviously. And even though it might be in writing in one instrument, it needs to be in a separate instrument. And look at that last bullet down there. The statute provides that the waiver is only effective if it is made during or after a period of military service. So blanket waivers, while somebody's a civilian, do not act to waive their rights under the SCRA if that contract becomes protected by the act. Go back to the first slide. This statute alters the terms of conventional contracts when the contract obligations become protected by the SCRA. 3920 simply says you can give somebody a power of attorney to be your legal representative. 3914 are really real holdovers from World War I, when many of our aviators went to the Royal Flying Corps before the United States got in World War II, and many of our allies incorporated Americans into their services in a war that was for everybody's protection. So that's where 3914 comes in. I have to tell you, I thought at one point in time that individual Americans who had dual citizenship with Israel and America might well be protected under that statute. But I think if you go a little bit farther, that it probably won't, unless we're involved in a war at the same time and in the same place with Israel. But kind of interesting, another historical background there. Okay, 3931 protects the service member against the entry of a default judgment unless the moving party has gone through the right provisions. And what they have to do, what the moving party must do, is file a motion with the court to appoint an attorney to represent the absent service member. They have to file, the moving party must file an affidavit with the court. And that affidavit must say the person is on active duty, or the person is not on active duty, or we can't tell. And if it says the person is on active duty, or we can't tell, then the court has to take some further action. If they say the person is on active duty and the court fails to appoint an attorney to represent the interests of the service member, that is a voidable default judgment, and we see them all the time. And they, with appropriate action by the service member in the time set out in the statute, they can overturn that default judgment if they can show that they were materially affected by their service, i.e., I'm in a foxhole in Fallujah. I can't come back to contest General Motors, the GMAC's action to seize my car. And I couldn't do it then, and now I'm back and I want to protest because you, court, did not enter an order appointing an attorney to represent me. And if the defendant is in the military, the court really cannot enter a default judgment until that attorney is appointed to represent the member. The court shall stay the proceeding for a minimum of 90 days on application of that counsel or on the court's own motion. And the court may extend that stay if it wants to. But the court must determine that there may be a defense that can't be presented without the presence of the defendant. And I'm hard pressed to think of any situation in which the presence of the defendant could not present some type of defense, or if the counsel says after due diligence they've been unable to contact the defendant or otherwise find that there's a meritorious defense that exists. Now, the attorneys who are appointed to represent these service members can't just send a letter to the last known address and say, this is your notice. They are appointed as attorneys, and they must take actions, whatever they can do, to find the defendant. How about propounding some interrogatories to the creditor? What's the last known address? What's the person's date of birth? What's the person's social security number? Because armed with those three terms, you can do a search, and we'll show you in just a minute, and find out whether the person is or is not on active duty. Setting aside the default judgment must be done if during the period of active duty or within 60 days thereafter, the service member applies, shows that he or she had they were materially affected in their ability to be in court. I was overseas in war. It doesn't have to be overseas, though. It could be that I was in a school and I could not take leave during that school. I could not get orders. I can't go anywhere I want to. I have to have military orders. I have to be on leave. If that would be materially affected, and they must be able to show that they had a meritorious defense.
Recall our earlier mentioning about the two Supreme Court cases, Boone versus Leitner, and the other case. The two of them, when read together, can be very helpful in these types of situations.
Exactly. Section 3931 applies regardless of whether the obligation under which the creditor is seeking a default judgment or the moving party is seeking a default judgment, regardless of when that obligation occurred. So in that regard, if a default judgment is what the moving party is seeking, 3931 is broader than the protections against non-judicial mortgage foreclosures, because it applies regardless of when the obligation was incurred. So it could be an obligation that the service member entered into after he or she was on active duty. It's still protected under 3931 against a default judgment, except those that are rendered in compliance with the statute. Here's how you challenge. You file a motion within the time limit after the person is released from active duty within 90 days of that. Now, where I have had great success is I usually come into the picture after the wrongful foreclosure has taken place and the property has been sold to a bona fide third party, or after the default judgment has been taken against the person and the damages have already occurred from any number of things, a bad credit rating, that type of thing, or the repossession of the automobile and the automobile's gone. That's when I come in, and that's when the case, quite frankly, from a plaintiff standpoint, is much more valuable. If it is a vain and useless thing to set aside the default judgment, then I believe you have your case for damages in that case. You're going to find that if you file one of these motions to set aside a default judgment, I'm going to tell you right now, opposing counsel they don't have a clue on what you're doing because they've never seen it done. It's very rarely done, but that's what the statute says. And be prepared to challenge the inactivity or the inaction of that court-appointed attorney. Now, believe me, I don't like suing lawyers, but I have done it when a court-appointed attorney didn't do anything to protect the rights of the service member that he or she was appointed to represent. I have brought an action against them for malpractice and have been successful in getting settlements on that type of action.
John,
Okay.
go back
Yes,
to the previous slide,
Yes, sir.
the one before that. Material effect. It is conspicuous. The definition of material effect is conspicuous by its absence in the statute. We deliberately and intentionally left it undefined so that it can be broadly construed. Remember the two Supreme Court cases that I mentioned earlier, Lemaistre versus Leffers and the Boone case? Material effect should be read in a light most favorable to the service member. And as Colonel Odom has pointed out, meritorious defenses may be in the eye of the beholder, but again, in any type of ambiguity, the tie goes to the runner here, and courts give deference regarding material, what constitutes material effect.
Remember slide number 1, the SCRA only means what the judge before whom you are arguing it means at that particular time. This is an incredible opportunity for advocacy on the part of your client. If you're representing a service member, you get to educate the judge, the law clerks, the opposing counsel. And if you're right, if you're pick your battles now, but if you're right, you really are right, and you have Supreme Court backing you in Boone versus Leitner and Lemaistre versus Leffers. Okay.
John, is this a good point for you to discuss the Conroy versus the state of Maine?
I want to get to Conroy under another slide, but we'll get to it in a second. Okay.
Good.
Here is the black letter law in red letters for you. This is what Title III means. It's simple. No. I'm sorry. One more thing. I ran into an Alabama judge, federal judge in Alabama a couple of years ago, who said, you're right. The court did not appoint an attorney to represent the absent defendant. And the moving party's counsel did file an affidavit that said the person is on active duty. But you can't sue the courts in Alabama. They have absolute unfettered judicial immunity. And the plaintiff's counsel had done what he or she was supposed to do. They filed an affidavit with the court that said this person's on active duty. It was a very unpleasant hiatus that left the judge saying, you can't sue me, partner. I got judicial immunity. And you got the plaintiff's counsel saying, hey, I did what the statute said I was supposed to do. Somebody is supposed to appoint an attorney. Well, normally the judges want the motion to be made to appoint the attorney by the creditor's counsel. So creditor's counsel don't just file the affidavit that says the person is on active duty. Couple that with a motion to appoint counsel to represent the absent service member. That's sort of a little pitfall there that I ran into, and it hurt a lot, I can tell you that. All right. in addition to default judgments, there's another provision in 3932 that says, as long as the defendant has not made an appearance with the correct letter from the service member and the correct endorsement in a separate endorsement by the commanding officer that military leave is not authorized at the present time, the service member can apply to the court for a stay of the proceedings. Now, those of you who've been around a while know that in the old act, whether to grant that stay in the proceedings or not was purely within the discretion of the trial court. And I never found an appellate decision that said the trial court abused their discretion. The law has changed. I'm stomping on the floor. This one's going to be on the final exam. Now, if the application for a stay is made and the commanding officer provides the appropriate endorsement confirming that leave cannot be granted at the present time, the stay must be granted for at least a period of 90 days, and that gives the opportunity for communication with counsel. The stay must be granted for at least 90 days. It's an automatic stay, and it can be extended beyond that if upon subsequent application. That's a very important change in the law from the old SSCRA. It does not constitute an appearance for jurisdictional purposes, and it is the legislative removal of a conundrum when, in the old days, Army legal assistance attorneys would write to the court and say, please don't proceed against Airman Snuffy because he's in Germany right now. I can't come home for a hearing on the repossession of his car. And some judges would say, well, thanks for making that appearance. I guess Airman Snuffy is going to get a default judgment because now he has counsel and he's had an appearance made by that legal assistance officer's letter. That legislative removal of that is very important for legal assistance folks. As I said, the stay can be extended by the court, but that's discretionary. Okay, it's critical on a 3932 stay application to just go to the statute and write the letter for the serviceman. Don't let the dummy do it himself, okay? Please write the letter and track the language of the statute. Just go to 3932 and look and see when that judge must grant the stay and track your letter so it does that language, and the commanding officer's endorsement does the same thing. So write the letters for the client, please. I think that's the only way you want to do it. I'm going to skip over fines and penalties. 3934 is there as the last line of defense. If you've screwed up and you didn't ask for a stay and they've taken a judgment and something you didn't do something right on that, you can go in and you can ask the court to stay the execution of the judgment or vacate the attachment or the garnishment that has been entered. And if the court believes you and believes that the person was materially affected, the service member, the court can even do that on its own motion to stay or vacate the judgment. That's very rarely encountered, but that's your last line of defense there. If you go beyond that, I can't help you. That's it. The duration of that stay can be for the entire period of service plus 90 days thereafter. The court can, if they want to, redo the judgment to provide for terms that the service member could meet, and the plaintiff may proceed against any defendants who are not in the military during the period of the military member's stay. I doubt if that would happen because courts don't like to do litigation over on the same cause of action. It renders sometimes judgments that cannot be reconciled. Now then, this is the one that's going to blow everybody's mind. 3936 provides that during a period of military service, statutes of limitation, we call them prescriptive periods in Louisiana, whether they are liberative or acquisitive, do not run in favor of or against a service member. The most recent pronouncement of the U.S. Supreme Court was a 9-0 opinion in a case that Mr. Huckabee is very interested or very instrumental in getting brought, called Conroy versus Anascott. Conroy was a lieutenant colonel in the Army. He got orders to Germany. On his way to Germany, he stopped in Danforth, Maine, and he bought some retirement property out on a little lake there. I'm picturing it had green trees around it and loons swimming on the surface, and it was very nice. And he left a forwarding address for his mail with the town council. Well, that forwarding address expired 6 months after he left. Some period beyond that, they sent out tax notices on the property that Conroy had purchased. The tax notice was returned undeliverable. Maine had a very short period for the redemption of property that was sold at a tax sale. I think it was just a year. And when Conroy came back from his 3-year tour in Germany, he stopped at Danforth, Maine, and he said, you know, I think I owe y'all some back taxes because I never got a tax notice. And they said, well, no, you really don't owe us any back taxes because you don't own any property here anymore. A guy named Aniskoff bought your property at tax sale. And Conroy said, wait a minute, I don't think that 1-year redemption period applies to me because I've been on active duty the entire time. And they said, sorry, Charlie, the moving finger writes and having writ moves on. Well, he filed suit against Mr. Aniskoff saying, I want my property back because this period of the redemption period was in the nature of a statute of limitations and it never began to run against me because I've been on active duty the entire time. Well, he lost at the trial court level. Maine doesn't have an intermediate court of appeal. He lost at the Maine Supreme Court level. Enter then Lieutenant Colonel Huckabee. And Huckabee thought that was a perfect test case on the applicability of the statute. And he unveiled upon a friend of his, a former Supreme Court law clerk who was at that time with Jones Day, Revis and Polk, a big time law firm in Washington and other locations. And Huck got the lawyer on a pro bono basis to write a cert application to the Supreme Court. Lo and behold, they took it up, and lo and behold, they entered a judgment 9-0 in favor of the service member. And Justice not Siric,
Scalia?
Scalia, thank you, Huck. Senior moment. Scalia asked the person in oral argument, Huck was in the courtroom, what is it about?
He was the Attorney General for the state of Maine.
What is it about this you don't understand? It says they don't run. And when I was preparing one of my earlier lectures on the SCRA, I called the city attorney for the Danforth, Maine, and I said, I was just trying to get some anecdotes to tell y'all today. And I said, was that the first time you'd been in the Supreme Court? And he said, yeah. A really, really down Easterner guy. And I said, was it an interesting experience? He says, yeah. I said, well, do you have any stories from it you can tell? He said, well, Mr. Odom, he said, I tell you the truth. When Mr. Justice Scalia and Mr. Justice Souda take up 20 of your 25 minutes of your oral argument arguing about where Danforth, Maine is located, you are not going to win that case. So thank you, Huckabee. You got Conroy versus Aniskoff on the books, and it's made it very, very clear that statutes of limitation do not run in favor of or against. So if a young airman out at Barksdale Air Force Base near where I live was involved in an automobile accident today, we have a 1-year statute of limitations to either sue him for the damages he may have caused or for him to sue the tortfeasor. If that young airman stays on active duty for another 25 years and then separates, the time continues to run only upon his date of release from active duty for whether he could be sued or whether he could sue somebody. That's a very difficult concept to make people understand. Now, under statutes of limitation, it's generally understood that after a military individual is released from active duty, the SCRA does not provide a specific statute of limitations because it would be variable. If the person was still on active duty, they wouldn't have a statute of limitations they had to worry about. But there is a general federal statute of limitations that says if not otherwise provided in the legislation, there's a 4-year statute of limitations from when the statute would begin to run. So let that be something in the back of your minds as well. We've talked about the maximum rate of interest. Mr. Huckabee, do you want to talk a little bit about 3937 and the reduction of that?
Sure. This actually has its genesis in 1918 in the original Soldiers and Sailors Civil Relief Act that authorized the cap of 6% on what you could charge a service member on, regardless of what they sign, regardless of what the contracts state. The statutory prohibition says, look, you can't charge a service member more than 6% on indebtedness. Well, we kept that, and I can tell you that we caught a lot of heat from the mortgage and banking industry wanting to do away with that or move it up to 12%. We said, no, we're going to fight to keep it. And with the aid of the American Bar Association, we were able to preserve it. The original statute was silent on the issue of forgiveness. So clearly, if a service member leaves active duty and now is going to have to pay the difference between 6% and the contract rate, that probably would do more damage to him than anything. So in our rewrite of the statute, we specifically stated that all indebtedness above 6% is forgiven. So that is crystal clear. Now, you're also going to have situations where you have multiple parties on the same indebtedness instrument. Let's take, for example, doctors and medical groups, or spouses and dependents who are also listed on the indebtedness instrument. The 6% cap applies to the entire instrument, and the excess is forgiven. Now, it's critical in order to claim this, because we have creditors, of course, who are unaware of the SCRA. And so the service member, in invoking the 6% cap, has to include a copy of their military orders that officially notifies the service member's creditor of the application of the cap. Now, this is really critical that usually during mobilization station processing, and again, the judge advocates are involved in these fill in the blank, letters. Hey, you need to send this to your creditor, invoking the 6%, cap. And this is really adamant that you need to do that. Now, this applies only to pre-service credit obligations, not ongoing or new contracts that run interest. So now it's rare that you're going to have a case of where a service member can't show a material effect, because again, it's provided a broad interpretation and application. But I had a situation of where we had an attorney in Florida who was mobilized, and he owned a shopping center, and he wanted to have the 6% cap paid to his mortgage on this shopping center. So he got directed to me, and I asked him, so explain to me, how is your military duty negatively affecting your ability to pay your mortgage on this shopping center? He said, well, not really. And I asked him, well, are you still getting your revenue from your shopping center? And he said, yes. I said, well, so explain to me, what is it about your situation that constitutes material effect? He said, well, I just thought I could get it just because I was in the military and mobilized. No, you got to have some type of material effect. And of course, including a copy of the orders puts the creditor on notice that he better apply the 6%, and it can give rise. And I'll let Colonel Odom talk about one of his cases of what happens when the creditor blows off the notice of active duty for the service member and refuses or fails to apply the cap.
Thanks, Zach. In 2008, there were some important amendments to the interest rate provision. there are now two kinds of obligations. There are those obligations that are secured by a mortgage or a deed of trust or other similar security instrument. For those, the 6% interest rate cap extends for a period of 12 months after the person is released from active duty. REFRAD is our short acronym for release from active duty. So on a mortgage obligation, the 6% rate cap extends for a year after release from active duty. For all other obligations, such as credit card obligations, car notes, and that kind of thing, the 6% interest rate terminates when the person leaves active duty, when they're released from active duty. Now, in 2018, there was a very important provision added, and this was added at this is the creditors. Finally, I got all the amendments I needed. Now the creditors got one. They put a safe harbor provision in section 2018, in section 3937 in the year 2018. It is really interesting, but if the service member will just follow what he or she is required to do and send a copy of their orders to the creditor as soon as possible, then, or within 180 days after release from active duty, then they will be protected. But here's what the change was. If the creditor goes to the Defense Manpower Data Center's database and plugs in the right information, which is the service member's name and social security number, or the service member's name and date of birth, or any two of those three, name and either date of birth or name and either and social, if that comes back and says the person is not on active duty, then the creditor has a defense unless they have been served with a copy of those orders. That's why it's now tremendously important that you provide those orders, that your clients provide those orders to the creditor and let them know that they are on active duty. Sometimes big deal in the mortgage industry now is those mortgages become one of 10,000 mortgages in a tranche that is thereafter used as a mortgage-backed collateralized security, and they're put into bonds. And 99% of the VA-backed loans are held by bonds by Fannie Mae. So it's very difficult for an individual creditor to know which one of the mortgages is in a particular bond. It's almost impossible, as a matter of fact. So it's critically important to know that those mortgages may have been transferred or sold 2, 3, or 4 times. Now we're talking about pre-service obligations only. That mortgage may have been sold 4 times before a creditor gets the demand within 100, while the service member is still on active duty, for example. The creditor gets a demand that says, I want the 6% interest rate back to the first day of my active duty. And I can tell you right now, the creditor is going to say, well, okay, we'll give you the credit, we'll give you the 6% rate back to when we bought the paper, but we're not giving it back to you for the 3 years before that. They're wrong. I just settled a huge case in Virginia, in which a large national mortgage servicer tried to take the position that, oh, no, we don't owe you the refund of that interest. We don't owe you that 6%. Back 3 mortgage servicers before. Yes, they do. And I'll tell you this, if you go to the paperwork by which mortgage servicer A sells the package of mortgages to mortgage servicer B, I guarantee you there's a clawback provision in there in which A says, if you ever get nailed for any obligations that we were responsible for, then come see us. But the service member doesn't have to go back through the chain of everybody who has ever serviced that mortgage. That's a very, very big deal these days, I can tell you. Now, sections 3938 and 3938A, these have to do with child custody. I will tell you honestly, what you're looking at when you look at those 2 sections is a result of 7 years of my life watering down the statutes that a particular congressman from Ohio kept introducing. The SCRA is a design statute to have a bilateral relationship between creditor and service member. It is not designed to be used in child custody matters, because you take it from a bilateral contract to a trilateral contract, and the child has no say in who the court awards custody to. And this individual wanted to say that a family court judge could not consider as a factor in child custody awards that the person was a member of the Guard or the Reserve and might be mobilized and deployed, in which case they couldn't be a custodial parent. There's no child custody judge in the world. There's no family court judge on planet Earth who isn't going to consider that as one of many factors, but it cannot be the sole factor. And that's what we finally watered it down. So those are in there. I promised I would teach it, but I'm not spending much time on it. Okay. Here's the absolute rule in Title III. No self-help. Do I need to go over that more slowly? No self-help. That's all you need to know. You may evict people. If Huck, you started on this when it was $150 a month. Now it's up to $9,106 a month.
Well, we had to raise it a little bit.
Yeah. It's just, show me a GI who's in a $9,100 a month condo, and I'm going to go back on active duty.
That was the point of the exercise.
Thank you, Professor. It's not that you cannot evict someone, it's that you cannot evict them without going to court and getting a court order after a hearing in which the tenant has an opportunity to argue their case. And the judge can, if you see on the screen, adjust the obligation. He can say, ma'am, I understand your husband's in Afghanistan getting shot at, or your husband's in Djibouti getting bombed, or whatever. And I know you can't pay $1,500 a month, but can you pay anything? Doesn't he get a basic allowance for housing? How much is that? Well, it's $700 a month. Okay. I'm going to say that you can't be evicted as long as you're paying $700 a month for the privilege of continuing that occupancy. Now, they can defer the unpaid rent to another date. I'm not interested in that, but you have to have that hearing, and you have to have the opportunity for the service member or their dependents to plead their case. Okay, I'm not saying you can't repo the car and cancel the contract. I'm saying you can't do it with self-help. You can't send Joe the repo man down there to hoist it up on the back of a wrecker and walk off with it. You can't do that unless you go to court. Before you do that and have a hearing with a court order, and the court can stay the proceeding of the repossession or adjust the obligations. Okay, so I'm not saying creditors can't take steps to protect themselves. I'm saying they have to do it in accordance with the statute. Here's the big one, 3953. I'm not saying mortgage companies can't foreclose or seize property, but I'm saying they can't do it without prior court order after filing for a court order, service on the defendant, and if the defendant's in Afghanistan, that might be difficult, but that's not my problem, and a hearing in which the judge can adjust the obligation, can stay the foreclosure, can stay the seizure. The case in Virginia that I just finished involved the term seizure. Most of the deeds of trust and mortgages, especially those in the northern climes where you need to winterize the houses, if the creditor felt that their house was not being properly maintained under most of those deeds of trust, they have the right to seize the property. That is, break in, change the locks, drain the pipes, and all kinds of stuff. And the VA servicing manual even gave them that right. Didn't even mention the fact of whether or not the mortgage might become protected when the mortgagor went on active duty with the U.S. Army. Gee, y'all didn't think about that, did you, when you were writing your little servicing manual? And I can tell you that that case, which we just settled week before last, cost them a large amount of money for illegally seizing a house under a deed of trust that had that language in it. And I told them, look, you just take a red pen and you strike that self-help language. They disagreed, but then they paid. So no non-judicial foreclosures, period. Okay. The powers of a court are amazing under 3953. They can restructure the mortgage. They can set a time limit on when the foreclosure has to be stopped, but that only happens if the mortgagee goes to court, provokes that hearing. The court can order the creditor accept a lowered payment on the mortgage. It's really amazing. Those of you who live in South Dakota know that the Department of Agriculture issues mortgages for some rural properties. And I had a telephonic hearing with an administrative law judge for the Department of Agriculture one time, in which I said, Your Honor, you don't understand. You can halt this foreclosure. And he said, nonsense. The mortgage says that. I said, Your Honor, excuse me. It's not nonsense. Do you have a copy of the SCRA handy? And he said, well, no. And I said, what's your fax number? Can we recess the hearing? He says, well, it's right here at my desk. Send it to me right now. And I did. And he read it. And the next thing he said was, good God, I had no idea I could do that. And I said, not only can you, Your Honor, I think you're obliged to in this particular case. We got the stay of the foreclosure. So he can do what he or she, the judge, back to slide number 2, it only means what the judge that you are in front of thinks it means. And sometimes you just have to do that. Remember, 3953 is pre-service obligations only, and it protects against non-judicial foreclosures in the 27 states that have those types of foreclosure proceedings, unless before the foreclosure or seizure begins, they get a court order after a hearing. Okay. Now, let's go here. Huck, you were going to take the impact of foreclosures and repos.
Sure. Clearly, creditors can cause problems for service members regarding their credit scores, security clearances, all sorts of issues. And so when you're settling these cases, you want to try and get the security clearances and the other references, the credit scores and whatnot, cleaned up so that clients are not damaged significantly by, these reports. And as John has been pointing out, this is really an education issue, trying to educate creditors as to what the rules are that they are obliged to follow. And so if they make a mistake, in my experience with a number of banks is, look, they just want to be told what the rules are. Many of them are veterans themselves who are working at banks and mortgage outfits. And getting them to understand what is required, and they dutifully will make the changes and adjustments, restoring the credit of the service member.
Let me ask y'all to write down one particular phrase on that, restoring the credit. I want you to write down the term delete the line of trade. Delete, D-E-L-E-T-E, the line of trade. That's what you need the creditor to agree to do. The creditors can report whatever they want to the credit reporting agencies under the Fair Credit Reporting Act, and they can report delete the line of trade, which if it's showing a foreclosure or foreclosure in process or foreclosure has happened in the distant past, and you get that foreclosure stopped as a result of your action, then you watch that credit score will bounce up about 200 points when the remedy is delete the line of trade. It's an electronic entry. It costs the creditor nothing to do, and the credit reporting agencies will generally accept that and remove all of the 10 years of late payments and so forth and so on from the person's credit score. So that is an incredibly important phrase when you're dealing with creditors and trying to clean up credit scores. Get them to agree to delete the line of trade. Huck, you want to talk about leases a little bit?
Yeah. Terminating residential leases. We'll talk about motor vehicles in just a moment. But clearly, we talked about, pre-service leases. What about, leases that are incurred when a service member comes on to active duty? Guess what? There are protections for them as well. And so regardless of what the lease contract says, the creditor is going to have to recognize that there are protections that belong to the service member here. So the lease executed by a person who enters military service or executes a lease and thereafter receives deployment orders for 90 days or more, hey, this protection applies to them. So it's common, of course, to enter into leases, and now a service member on active duty receives orders moving their permanent change of station to another location. Very common, regardless of what the lease says. A service member may terminate the lease without any negative repercussions. This is a special protection because service members, to include, of course, reservists and guardsmen, get moved around quite a bit. So again, regardless of what the lease says, as Colonel Odom has cited, no self-help. This is a protection that permits service members to terminate such leases because they're being ordered from point A to point B and no longer need or can use the lease. Motor vehicle leases. This is something that really surprised me in 1990 when, for the first time since World War II, we were mobilizing guardsmen and reservists. I was astounded with how many service members had automobile leases. I was astounded. And of course, you know, there were all sorts of restrictions in these leases if a service member terminated them. Well, guess what? We have another protection here that we put in here specifically for pre-service leases, and also leases that service members enter into as a result of permanent change of station. Overseas, being having spent 9.5 years overseas myself, being sent outside the continental United States may require termination of your automobile lease. Same thing for Alaska and Hawaii.
One quick war story. When December of 2003, when the new act, as we call it, became effective, about 10 days later, I got a phone call from a legal assistance officer, a Navy legal assistance officer in Annapolis, Maryland. And he had a Master Chief Petty Officer, an E9 in the Navy, who had just gone down and leased a brand new Volvo. I think the top Volvo then was the 960. And he had leased a brand new Volvo, and he had gotten orders about 2 days later to someplace that you couldn't ship a car. I don't know, Antarctica or something like that. Who knows where the Navy goes? But he took the car back and said, I'd like to turn the car in. And they said, oh, you're not happy with the car? No, I can't take it where I'm going. Well, fine. But you need to write us a check for $12,400 and we'll be glad to cancel that lease. And I said, no, that's not how it works. That is not how it works. And by that time, the statute was so new that it wasn't published anywhere. And you had to go to the Congressional Record or the journals and get it and send it to the dealer. And then it was again back to slide number 2. It was an educational process because they simply could not believe that he didn't owe that $12,400 penalty for early termination of the lease. But that's again in the educational process, it can be done.
Guess what? We have that same protection applies to these business interests. Cell phone, telephone exchanges, internet, multi-channel, gym membership, home security services, those leases too can be terminated by a service member if the location they're moving to doesn't support the particular contract.
I made so much money off of storage warehouses, it was just senseless because something would happen. The service member would put all their household goods in storage, get an unaccompanied overseas tour to Afghanistan or to Korea or whatever, or a reservist would get called to active duty and they would put their goods in storage and something would happen. I don't care what happened. I really don't care whether the lease went unpaid or not. Once those goods went in that storage warehouse, and I don't care what state law provides, if they cut the lock off that storage unit because the lease wasn't being paid and they auctioned off those goods, I win. I win. All I've got to do is get a good inventory of what was in there. I think the highest I ever settled one of those cases for was $240,000. But it was just a lay down hand. They just wouldn't understand until shown in the U.S. code what they had done wrong. I said, well, you know, did you go get a court order to do that before you did? No. Well, sorry, you lost. And those were summary judgment proceedings. And normally I didn't even have to go that far. But I settled a bunch of those cases. That was the cotton crop of 2009 and 2010, as I recall. But we made a lot of money off of storage warehouses that didn't understand that. Taxes respecting property. A lot of states have taxes on real property, but also on personal property. You can terminate. I'm sorry, I went the wrong way. Excuse me. You can terminate, or you can't lose that property for not having paid those taxes if the tax arose either before or during the military service. You can apply to the court for a stay in the seizure and sale of those pieces of property. Okay, I'm going to blaze through about 5 slides because 4012 is really, we don't ever use it. No secretary of any military service issues these certificates of service. They're not even set up to do it. I don't know why we have that. You want to go to DMDC SCRA. All right, your Google, Dr. Google will solve this for you. DMDC SCRA, Defense Manpower Data Center, is the big database that shows whether you're on active duty or not. You have to establish an account. It's free. You just have to have a username and a password. It's free. You have to use that thing every 90 days or so, or the account will go vacant or go dormant on you. This is what you get back. It's a certificate of service. It looks just like this. This was one for me. I got recalled to active duty in March of 2010. I was on active duty until July the 5th of 2010. My status was, yes, I was on active duty and I was in the Air Force Reserve, but on active duty in the Air Force Reserve. So that's what the certificate will look like if you're either a creditor or a debtor. Go to the DMDC website, set up your account. There are ways for mortgage companies and large banks to put in batches of names, social security numbers, and dates of birth, and you can do it all electronically. They're really smart. Okay. It'll also supply the last date of active duty, and that's important because remember, under the interest rate protection, if the interest rate has been lowered on a mortgage instrument, it counts for an additional 12 months after the release from active duty. So sometimes you need to know a particular date to ask the machine. You just plug in the right date you're interested in. Ask the computer, were they on active duty on such and such a date? If the answer is no, then they're no longer protected by the SCRA. Okay, easy to set up the account, password expires, no charge. Now, here's something we just figured out. That DMDC website and the statute, by the way, provides that safe harbor in the interest rate protection. That safe harbor mandates that the creditor do a search in the Defense Manpower Database. Okay, that's what we just got through going through. Guess what? There are now 13 different states that have passed state legislation that says for state active duty for the Guard and the Air Guard, we adopt the rights, benefits, and protections of the Servicemember Civil Relief Act and the Uniformed Services Employment and Reemployment Rights Act as the law of this state. And guess what? South Dakota is one of those states. And Huckle, I've got the statute in the slides for you. But what that means is if Governor Nome orders a company of of Army, Guard, MPs, for example, or transportation logistics people to go south to help the governor of Texas protect the southern border, and those guardsmen are on state active duty orders, that's not going to show up in the Defense Manpower Data Center database. You can search that all you want. My client in the Virginia case had been on state active duty orders since 2004, when he got back from Iraq and had terrible injuries that rendered him pretty much incapable of going out in the world. And so they kept him on active duty. He never showed up as being a DMDC. This certificate, you could have asked until the cows come home for that certificate right there on my client, and it would have never shown him to be on active duty. But if you knew that Virginia was one of the states that had adopted the SCRA and USERRA as state law, then you would know that he was protected. And that was what we were finally able to convince them, the creditor, that the sergeant had been protected the entire time. Huck, here's your statute.
This is it. So we obviously are deploying from South Dakota a number of soldiers to the border. This clearly sets out that they're entitled to SCRA protection.
I will tell you what I've done. I've been a little proactive in this because I don't like it to be unfair to the creditors, he said, laughing, ha ha ha. But if you don't know anyway, how are you going to know whether the person is on active duty unless the person has done what they're supposed to do and sent you copies of their orders? So what I have done is I've reached out to the staff director of the Subcommittee on Economic Development of the House Armed Services Committee, and I've said, you got a bunch of states that are now adopting the SCRA as state law, and the DMDC website is not, or SCRA website is not going to show that. So we need some legislative fix on that. Not sure how that's going to happen unless maybe the DMDC agrees to expand its database to those states that have state active duty deals. But anyhow, that's a word, that's a warning for both the creditor attorneys and the individual attorneys. You've got to give a copy of your orders and the appropriate notice to the creditor now, because sometimes you're not going to show up. The service member is not going to show up in the DMDC website, but they're still going to have, under state law, the rights, benefits, and protections of the SCRA. Huck, you need to add anything to that before we go on?
No, just that the burden is on the service member to request the particular 6% protection and furnish a copy of their order. So the burden's on the service member to do that. We put that in there in order to ameliorate creditors who didn't want to get left holding the bag for something they had no knowledge of from their service member clients.
But there is no corresponding requirement in the mortgage foreclosure world. The mortgage foreclosures, I've got reported cases that say the obligation is on the seizing creditor to ascertain whether or not the person is protected by the SCRA. They could do that if they wanted to, but if South Dakota had adopted the SCRA's rights, benefits, and protections, that's not going to protect the creditor. It's really kind of unfair, but the way around that is for the service member to give notice. If the service member sends a copy of his or her orders to the mortgage company, then if they do it wrong, then I have no sympathy for them. But remember, there is some proactive that needs to happen on the part of the service member. He or she can't just sit there and say they messed me over. Okay. I'm going to skip over anticipatory relief because it's really complicated. And if you have a situation where you have a high earner who has a lot of debt, student loans, children in college, 2 Mercedes, 1 Ferrari, and they get called active duty as a major, call me and I will walk you through it. I'll even provide you with a sample complaint of how you can implead the creditors and get the court, if it's a willing and able court, get them to reduce the obligations for the period of the service. But we don't have time to do that one today. All right. Permanent change of station. We used to argue with creditors, mostly landlords in rent situations, whether the expiration of the term of service was considered a permanent change of station order. It is. Whether retirement orders are considered permanent change of station orders, they are. And the problem is when we got the legislative fix for that, Congress, in its infinite wisdom, chose not to put that in Section 3911 called definitions, so it would apply to every single section of the SCRA. I'd still like to get that moved sometime in the future. But here is a link that is a hyperlink that's active, and this is to the most current version of the statute through April of 2022. So you can click on that link, and it's a downloadable. It's 55 pages long now, but it gives you the legislative history on each individual section as well as the current text. And finally, that's Colonel Huckabee's contact information and my contact information. And I believe they wanted us to leave some time for questions. So Gary or Tracy, one of the two of y'all want to take back over the microphone and see what you want to do. Oh, they've left.
I will leave that to Gary.
No, he's there. Gary, unmute your microphone and tell us how you want to do the questioning.
Here and awake throughout. Excellent presentation. My thanks I'm sure of all our participants, which hit 28 according to my screen as a high, for your obvious a lot of work between the two of you doing this. Very helpful. I want to point out, John, one of your early comments was educate, it depends on the judge. This committee, and greater minds than mine, which is a pretty broad population, prepared the South Dakota legal guide to the SCRA, and it's available online to the entirety of the South Dakota judiciary. And I think any bar member can get it. So if you have such a thing and you want to educate that judge, make sure he or she knows that this reference is available, that will help you educate that judge on behalf of your client too. Are we there?
Oh,
Yeah.
we're waiting for questions. Would anybody like to ask us a question? You'll have to unmute your mic, but Sarah, your mic is unmuted. Do you have a question? Sarah has left for lunch. Anybody got a question? Huck, let me say once again, I really enjoy co-presenting with you. It really is like asking Moses as he comes down with the 10 Commandments, what did you really mean by number 7? But it's always a joy to get to team teach with you. And I appreciate all your scholarship and all the hard work you folks did in 2010 to rewrite this statute and put it in a little bit more modern terms and updated.
Our pleasure indeed. But thank you for zealously representing so many service members over these years. You made a difference in a lot of lives.
Well, one of these days I will put in the slides the photograph of my 1965 Pontiac GTO that I went out and bought with one of my fees, which has personalized Louisiana tags that say SSCRA. So
very nice. Well, it's important, and it's important that you pointed out, John, at the beginning that in 9/11 everybody's flying flags in their cars, and how quickly people forget. And you know, they may clap for you in the airport when you're walking down your uniform, but a year later when you have that uniform off, it's important that veterans know that they have a lot of these protections as well. So again, thank you both for a great service. I would invite, if you gentlemen could agree, that any of you lawyers or students out there participating want to contact either Colonel Odom or Professor Huckabee. I think they would probably be happy to entertain your inquiries.
the only thing I would add or ask in that regard, Gary, I'm happy to respond, but if you have a specific fact pattern, it will save a lot of time if you can send either of us an email outlining the fact pattern, and we can then get back with you by telephone and walk you through what you need to do or assist you in some other way. But an email works best, that I'm not trying to write down a lot of facts as you talk to me on the telephone, because despite my advanced age, I'm still in active practice and my time is a little bit valuable during the day, but I'm always happy to help whoever needs a little guidance on SCRA stuff. So is Huckabee.
Well, thank you, gentlemen, and maybe our paths will cross when you get out here to shoot at pheasants next fall.
Thank you.
All right, Tracy, do you want to end the program?
No, I'm recording this, so we'll have this on the materials on the website. It'll be under the CLE materials.
Okay, and then we exit for today then.
Okay.
Thank you again.
Thank
Thanks.
you.
All right. Thanks, everyone.
Bye-bye,
Thanks.
folks. Thanks.
Later.
Huck, good to talk to you again, buddy.
Well, thanks, my friend. Thank you so much for, spending time on this. I know we've been working on this the past couple of months, but